I think the theme is that it's usually better to talk to a lawyer earlier than it is later, because a lot of times when you talk to somebody early, you can usually solve a problem with a minimum of fuss and a minimum of expense, and talk to the lawyer by the time the problem has already sort of metastasized and become difficult. So with respect to any kind of benefit that you may be eligible for, it is often useful to have somebody take a look at it. That's all. And at the take a look at it stage is not a particularly tough or expensive thing. And my only point is that can help you later on. And that's what we see is setting up a company, right? And you know, do you set up an LLC? Do you set up an S corp? And I'm here to tell you that those specifics are not real important. What is real important is that you talk to somebody who helps you figure out kind of what happens if things go wrong when you set up your company. And so let me draw a distinction here. If you are setting up your own company and you are the sole shareholder and you're the only person doing it, frankly, there's not a lot of need for a specialized lawyer, right? You can probably use an internet law service for that in most cases. But if you are setting up a company with your brother-in-law, it seems to me that you probably want to figure out what happens if that person is no longer your brother-in-law, or what happens if you want to get out of the company, or what happens, or how are you going to make decisions, or what happens down the road when you and your partner or you and your partners don't agree on stuff. And the basic function that a lawyer can serve is to help you figure out what are the things that are likely to arise, what are the things that might arise, and how do you figure out how to resolve those things before there's a fight. And so, you know, invariably when I do these things, again, people ask about the, you know, internet services or sort of all you can eat kind of, you know, you pay a couple $1,000 and you get, you know, use of a lawyer whenever you need one. And those things are fine, but they're not real good at solving the problem before it becomes a problem. So one of the things that we do is we help make sure that the operating agreement is specific about what happens here, what happens there, how do you set up a process by which you can actually kind of resolve things. Something that a lawyer can do is help you make sure that when you draft the documents to go into this business, that you're doing so to make sure that you actually have control, and that there aren't provisions in the agreements that really give the other guy control when you should have control.
Whatever form you elect to form your company in, make sure that you follow all the formalities of that organization. You know, it needs to have a separate bank account, and when you do a job and you get paid for it, it needs to go into the company's bank account. When you have expenses, it needs to be written from the company's bank account. And this is significant because if you do a job for somebody, let's say you're hanging sheetrock and all the sheetrock falls off and hurts a bunch of people, unless you have followed your corporate formalities, they may try to sue you individually and personally rather than, and they'll probably also sue the company. So you want to set it up so that if the company gets sued, that they can't come after you and sue you individually and hold you personally liable. We're involved in a case right now where there are allegations that small business, veterans preference rules have been violated. And the allegations are that there's this big company that didn't qualify, teamed with somebody who did qualify, but really the person who qualified didn't really do the work, wasn't really getting the bulk of the contract. And these can come up both civilly and criminally. There can be, the civil penalties can be incredible. So in the context of the Small Business Administration, they have actually a rule, a regulation that says, let's say you win a contract, you say, I'm gonna sell you shoes that will cost $10, and the government says, perfect, that's a great price, we'll buy them. And they get exactly what you promised that you would give them. But it turns out that you weren't qualified to under this contract for this preference. The government has a rule called the presumed loss rule. And the damage to the government is not the difference between what they thought they were buying and what they actually got, because they got what they thought they were buying. Instead, they will say you are liable for the entire value of that contract. So if your contract was for $1 million and they got $1 million worth of shoes, it does not matter. They will sue you for $1 million. And so it's ruinous if you get wrapped up in one of these. And then they have criminal penalties as well. So you got to be very, very careful when it comes to these preferences, because the government does police these.
One thing I often tell clients is if I tell you something that is against my financial interest, you probably ought to listen to that, right? So we were talking about Travis Green called up and he has got a business, and I want to describe it with some specialized prosthetics that he's working on, and by all accounts, it is a very successful business. And he called up because he had my number and wanted to know some questions about import regulations. And I know enough to know that if you get it wrong, that's a real problem. And so in this case, I have a buddy who specializes in Food and Drug Administration and import stuff. We got my buddy on the phone with him, right? And I knew that I could put him in good hands. And so it is very, very easy to dispute things. It is very easy if you want to sort of run up somebody else's bill by disputing things. And people seem to think that if they have a good piece of paper, that a bad relationship can work. And that's just not the way the world works. It's not the way the world works. It's good to have a good piece of paper, but it is not something that'll make a bad relationship work well.
Once you negotiate the contract and it goes bad, then that's when I will typically get involved. When you get into litigation, you have to understand one thing going in. It is going to suck. It will distract you from your business. It will consume all your free thoughts. It will consume your money. It is just an unpleasant thing to do. And you also need to realize that in most circumstances, your lawyer's interests and your interests are not necessarily aligned, right? You want to get this thing resolved as quickly as possible. What does your lawyer want to do? He wants this to drag on for years because you're going to be paying him all this money. So you got to make sure that you trust your lawyer, and that your lawyer is not only your advocate for your case, but is someone who will give you sound counsel about whether something's worthwhile proceeding with, or whether it's in your best interest just to get this thing resolved very quickly. Right. And so that's why the lawyer's got to help you look past that emotional reaction to something. And when you're dealing with your business, you've got to make sort of a hard, cost benefit analysis. Is the potential return worth the investment that this litigation is going to take? And so your lawyer can help you do that. Because of the potential of litigation, this is another reason why it's helpful to have a lawyer in advance to help you think about these things to put in the contract, because there are certain contractual provisions that you can include that can help minimize some of the risk and kind of make people think sanely about this. One is, you can have a forum selection clause. I mean, if the guy you're contracting with is in Colorado and you're here, well, pick that any dispute has to be filed here, or in some other location that's more convenient for you. You can include a provision that says the losing party has to pay the other party's attorney's fees. And so when you go into litigating, you're like, well, geez, if I lose, I not only have to pay my lawyer, but I got to pay the other guy's lawyer. That kind of provision will help people think sanely about these things, both sides, and try to find an amicable resolution. Arbitration is another provision that your lawyer can counsel you on, because that typically can get done quicker, and it costs much less than kind of full-blown litigation in either federal or state court. So there are some things that you can do to help minimize the cost of litigation. The founding partner has this saying that a bad settlement is better than good litigation, and that's absolutely true. In a settlement, nobody's going to be happy, and that's probably a good thing. That means it's probably a good deal. You're going to wish it would have turned out better, but you're going to get something. And that's much better than spending years litigating cases. And they can take years and years and years to litigate.